Ladies and gentlemen, good afternoon. I'm Regina Quick, and I'm the Vice Chair of the Juvenile Justice Committee. Chairman Weldon had an unexpected family emergency literally just moments ago, and so he could not be with us, and that was quite unexpected. We're going to be at ease because Senator Unterman is conducting her own hearings in her committee in the Senate. And so I just wanted to let everybody know what was going on, and we will be just at ease until we hear from her as to how she'd like to proceed and where she is in her schedule and her agenda there over on the Senate side. So thank you very much for being here with us. In fact, going to be detained, and so that's the bad news. The good news is we have her House stunt double, or what will we say, Representative Estration? I'm not sure, who had a companion bill or a similar measure in the House, which was House Bill 244. Is that correct, Representative? So as we call SB 8, Senator Unterman's SB 8, if you have not signed up to speak, there is a sign-up sheet. Please come up and sign up, because we'll be taking that up momentarily. But if you've not signed up, come on up. All right, Representative Estration.
Thank you, Madam Chair. Members of the committee, appreciate this opportunity to review Senate Resolution 7 and Senate Bill 8 for your consideration today. This is as adopted in the Senate, so I don't believe LC numbers are necessary here. Madam Chair, if it's acceptable to the committee, I'd like to begin by providing just a brief overview and also just going through section by section, as well as bring some testimony before the committee, both from Mr. Chuck Boring, Assistant District Attorney in the Cobb Judicial Circuit, who's here today to testify, as well as if I could ask Representative Welch to give testimony as a co-author of this legislation concerning the introduced House bill, as well as an individual that testified at the Senate committee hearings. I'd appreciate that opportunity.
So, all right.
Thank you. Madam Chair, in this country, it's well documented that we have a crisis with the sexual exploitation of children, with specific cases that can be documented here in Georgia as well. Senate Resolution 7 and Senate Bill 8 are brought for your consideration here today to address this crisis. Madam Chair, this is legislation that's being proposed as a constitutional amendment for consideration by the voters of Georgia in the general election in 2016. Senate Bill 8 is the companion legislation to provide enacting provisions. It would also provide increased civil and criminal penalties in a variety of areas to address the underlying issue with the sexual exploitation of children, and would also create a dedicated fund so that rehabilitative services, housing, medical services can be provided to children that are victimized due to this criminal enterprise, and also to provide for preventative measures to ensure that this does not continue to occur, or that it's prevented where possible. So to begin first with Senate Bill 8, I'll just begin in Section 1. The legislation is titled Safe Harbor Rachel's Law Act. Representative Welch, in Senate testimony, went over Rachel's story, that she was the victim of sexual exploitation and was trafficked to Miami from Georgia to be exploited. And with her courageous testimony that was presented at the Senate committee hearing, senators were able to hear firsthand about the experience of that, the need for supportive services, and the courage that she was willing to bring and publicly discuss the way she had been victimized. And the fact that she is an individual and that she will not let what happened to her define her. And she wants to be a voice for other children that have been victims, and wants to do what she can to see that legislative action is taken. And I certainly applaud her courage and willing to appear. The General Assembly would make certain findings, or the Senate in the legislation passed made certain findings that are included as part of the bill. Madam Chair, Section 2 of the bill deals with increasing the age with which a civil action could be brought to the age of 25. And I've spoken with Representative Spencer, who carried House Bill 17, and some of the similarities that exist in the legislation. Although this is not, of course, it does not mirror Representative Spencer's bill. It is in line with the issue that was debated by the Georgia House recently on that bill.
Representative, is it in conflict with HB 17 with regard to the provisions in Section 2?
Well, that's actually difficult for me to say at this point. Of course, Senate Bill 8 was passed before House Bill 17 was passed, Madam Chair. Be happy to analyze that or determine if there'd be a signing order issue, and would be happy to speak with Legislative Counsel about that.
All right.
Section 3 of the bill discusses the creation of the Safe Harbor Fund for Sexually Exploited Children and a commission to oversee the use of the fund. And so I'm happy to detail the specific provisions and aspects of that, but a major component of this legislation is working in that area. Madam Chair, Section 4 of the bill involves permitting civil forfeiture actions by law enforcement in certain criminal offenses where it's not currently permitted. And this is done at the request of law enforcement officers. At the Senate hearings, several different law enforcement officers spoke. At when this bill was initially introduced, the chief of police in my home county spoke in support. Madam Chair, police are seeing that pimps and those working to sexually exploit victims are operating criminal enterprises, similar to what we've seen in the past in cases of drug trafficking. And law enforcement is requesting similar tools so that this can be addressed. Specifically, law enforcement officers will make an arrest for an offense such as pimping, and the very next day, that offender could be bonded out of jail and be right back on the street operating that same criminal enterprise, using the same motor vehicles or assets that have been used in the furtherance of those crimes. And law enforcement has made the request, similar to the way that we treat those that are selling drugs on the street, permitting the state under a structure to seize assets that are being used in furtherance of a criminal enterprise, for the state to take action against those individuals in a similar way. The offenses that are listed, I know that code sections are only here, but it would first of all remove an age requirement as far as the offense of pimping, would also add keeping a place of prostitution, pandering, and pandering by compulsion. All right, in Section 4-3, it was noted that there is apparently an issue that exists with, and I believe Mr. Boring is going to be able to testify about this, but current statute does not specifically identify human trafficking for sexual servitude, an existing crime, as being classified under the required offenses for registration as a sex offender. And this bill fixes that as well, adding that those offenses specifically. And Madam Chair, this is similar to other legislation that has been pending in the House, and at the appropriate time I'm happy to discuss a potential addition that can be made in this area to clear up some venue discussions that have taken place or were a component of this other legislation that was pending.
Representative, can I ask you how the forfeiture provision that you were talking about in Section 4 squares, if it does, with all of Chairman Atwood's hard work on, I believe it was it HB 233, Chairman? And if you know, and if not, I guess we'll get to that at some point in terms of how it meshes together, but can you address that?
Yes, ma'am. Thank you. That issue was addressed. I previously offered testimony on that exact issue. It's my understanding from Legislative Counsel that the provisions as part of Representative Atwood's legislation would mesh with what has been proposed here, or if necessary, Legislative Counsel has a means by which of making that consistent. As the chair is aware, I was carrying similar legislation in the House and dealt with this very issue in subcommittee, and it's my understanding that the language has been or can be made consistent. I'd be happy to look into that and follow up with the members of the committee.
I think we would want to do that, and I don't want to interrupt the flow of your presentation, but I do want to come back to Chairman Atwood first when we take questions.
Yes, ma'am.
Just go ahead.
If it would be all right, Madam Chair, I would like to move at this time to the testimony from Mr. Boring and give him an opportunity to give an overview of his work, the cases that he's observed in different counties where he's worked, and his thoughts on the legislation. And if I have some follow-up questions, I'd just like to ask them then.
All right, we'll do that, and we will go to him first, but I want to make sure I get any of the committee members' questions of you so that they're not sitting with unanswered questions while we're taking testimony. So let's go first, Chairman Atwood.
Madam Chair, I checked as of yesterday, and there was no conflict with my bill.
Thank you, sir.
Thank you.
Representative Oliver.
This is really a process question, Madam Chair. Would you prefer that I ask questions or we be asked questions at this time and have a discussion at this time that might take a little bit of time, or would you prefer to hear witnesses first?
I just want to make sure there's nothing about the presentation that you need clarity on before we go on to the testimony, because it is a hearing only today.
There are aspects of the bill that I have questions about that I think the committee would like to discuss at some point, but I didn't know whether you wanted to hear witnesses first. That's your preference?
Yes, it is, and unless it's something that you absolutely positively need to clear up before we go on.
No, I don't. I'm really asking, courtesy of the witnesses, might be that they should go first, is what I was thinking you wanted to do before we discuss the bill.
Let me just make sure nobody else has a burning issue. Hold on just 1 second. Is it Representative Spencer? Is that you?
Madam Chair, I'll wait to ask questions after the witnesses.
All right. And down front, is that Representative Evans?
Yes, thank you, Madam Chairwoman. Just a quick question about something that you said, Representative. You said that the bill removes the age requirement for pimping, and could you direct me to the line number? And you talking about for the pimp or for the victim?
It's for civil forfeiture proceedings when the underlying offense is pimping. And currently there is an age restriction as to when civil forfeiture could be pursued, and I'd be happy to pull that line for you.
Is that your only question, Representative?
Yes. the first time I've ever been able to say thank you, Madam Chairwoman, and I really appreciate the opportunity. Wish I could say
We'll
it more
hope you
often.
continue to feel that way.
Representative Evans, it begins on line 338. And the existing code section is 16611, and you'll just see there where the additional code sections have been inserted as the code currently reads. Language there has been addressed.
All right, let's hear from, was it Mr. Boring?
Yes, ma'am. Guess kind of starting from where Representative Evstration ended, regarding the sex offender registry and human trafficking being a registrable offense. Currently, as it stands, there's an argument that if a victim of a crime of that nature is a minor, that person, the offender, would have to register. However, there is a hole where you have somebody that's convicted of human trafficking for sexual servitude involving somebody that's an adult through coercion, brutality, anything like that. And so I think that is something significant. For example, when I was in the Fulton County DA's office, I was involved in a case several years back involving a defendant who was running an organization with several co-defendants, ended up being co-defendants in this case, including other women working as prostitutes as well. One of the people involved in his business was basically 19 or 20 years old, decided she wanted to leave the life. She fled from his business on Fulton Industrial Boulevard in a hotel there to Midtown, where the defendant in this case, the main, I wouldn't say mastermind for this guy, he was not brilliant by any stretch of the imagination, but the guy running the organization sent his henchmen, so to speak, to Midtown to find her, basically to punish her for leaving the organization. She was taken back to that hotel on Fulton Industrial Boulevard, where she was beaten repeatedly, brutally attacked by these people, locked in a dog cage, and made to stay for several days until the police were called on some other event and actually stumbled upon this room going in and found all of these things going on, interviewed the victim, and then it came out what had actually occurred. That defendant ended up entering a plea, and for that offense, he does not have to register as a sex offender. So I think that is a hole that would be an easy fix, in my opinion, prosecuting these cases. I guess that's the first course of business here. Second of all, regarding, I believe, the forfeiture issues, how that would be helpful, we do see that repeatedly. Kind of a case I'm going to talk about now that we just completed in Cobb County last year involving a 14-year-old runaway victim. The girl had run away from home from the Clayton County area, and after going through several jurisdictions, frankly, with several other exploiters, ended up in Cobb County with this particular person. She finally, her family got in touch with her. The police arrived, found the defendant with this 14-year-old and another adult offender, female offender in the hotel. Charges were leveled against this offender, and he ended up pleading guilty. The victim, as you may expect, had some mental issues. We went back and looked, though, in building the case at some of the other arrests that this offender had, and while he was never charged with human trafficking or anything like that, we found a number of occasions going back 3-4 years where the defendant had been arrested in a hotel with runaways, all underage, who, if any of you know anything about this type of crime, these young girls are pretty much hard eggs to crack right off the bat, and they're not going to disclose a lot of what goes on. But looking back at that, there were arrests of these offenders for some of the adult people who were working out of the hotel. They would be arrested for pimping and things like that. In going back and investigating that and building our other act evidence and showing this is this man's course of conduct, we pulled the police reports and the evidence collected in those cases. And time again, the other girls would be using his money that he'd made from this enterprise to bond him out. On cell phone pictures where he was posting ads on Facebook advertising these prostitutes, there would be advertisements where his car, the same car he'd been using for several years, were showing up in ads he had used years back. He'd been using the same red, I believe it was a Malibu, again and again were popping up in these police reports. I think that case is an example of how this is an enterprise, and these people, when they are locked up and bond out and things of that nature, it would be a helpful tool to have the police have a tool, even when it's not a minor that's arrested for this or that is a victim of this activity, to be able to seize their assets and stop this, because it's kind of a cost-benefit analysis. If it's worth it more to take a chance to go to jail and bond out, and you're making enough money to pay for it, I mean, what's to stop you? So,
Madam Chair, may I ask one question? And Mr. Boring, in any specific case, do you recall where property had to be returned, including a firearm?
in this specific case, actually, because there was no offense for which they could keep his firearm or no evidence of its use in the actual act, although we know that firearms are usually used by people that commit these crimes and to intimidate, especially minor victims and things of that nature. We found the same firearm on this defendant in the case in chief that I prosecuted that he had had on him at least once, and if I remember correctly, maybe twice over the years. So, and I think finally, I know in this case as well as an example, part of what happened to that 14-year-old girl, they actually had created a fake ID for this child and were attempting to, on one of the nights, take her to a club, and they were going to get her into a club. And I've seen this in numerous cases in a couple of jurisdictions where oftentimes they will attempt to get the young girls involved in the adult entertainment industry, either through, these not exactly the most well-publicized places, but lower-level establishments with fake identifications. That is often a gateway to getting them comfortable enough to perform sexual acts. In this case, they actually were in the process of doing that with this girl. And one of the other offenders involved in the case was this woman was in her mid-30s. She was also working at that club as well. So I think that case is an example of the correlation and kind of as this industry can be a gateway to young girls getting involved in the sex trafficking business. So.
When you say this club, what type of club was it?
Oh, that's strip club.
And when you said this industry, were you speaking of the adult live entertainment industry?
Yes, correct.
Madam Chair, as I kind of transition, if it would be all right, transition into the resolution as well, I'd like to, if it's acceptable to the committee, just to address some of the provisions that Mr. Boring's provide a segue to here, if that'd be acceptable.
That's perfectly fine, and I think it might benefit the committee, especially those that are lucky enough to not be lawyers, for you to explain why the resolution is necessary from that perspective.
Yes, ma'am. Thank you. So the resolution is introduced as a constitutional amendment for consideration. That is a necessary step for constitutional referendum to be put before the voters, and passage of the resolution does not require supporting. Passage of the resolution is a component of this, but the Senate Bill 8 would provide the enacting legislation with which, should the voters approve this ballot measure, the means by which it could be enacted. So, Madam Chair, I would defer to Legislative Counsel otherwise. I hope that's a sufficient overview.
And I think it also would bear mentioning that in order to dedicate the funding in the way that is proposed in the legislation, without the constitutional amendment, it would go to the general fund.
Thank you, Madam Chair. That's correct. Thank you. And the creation of this specially designated fund with the use provided is included in this legislation. As was previously presented in the Senate committee hearing, as I expect to present to this committee in the form of affidavits and citations to news media articles, this legislation, and consistent with the testimony that the committee's heard from Mr. Boring, a prosecutor in this state, in Metro Atlanta, I will be submitting and requesting similar legislative findings to that which the Senate's found, or approval of the Senate language, in that this fund is to be supported by and paid into by offenders that are convicted of offenses that are specifically designated. The offenses that I mentioned earlier, as well as solicitation offenses. And Madam Chair, this really goes to attacking this issue from both the demand and the supply side, going after the pimps, but also having provisions in place where those, the Johns that are soliciting these children are also facing sanctions where they would have to pay into the fund after conviction. And I'd submit that, that is similar to what is currently done on other criminal offenses with a designated fund and a designated purpose. Additionally, the legislation provides for a fee to be set on all adult live entertainment establishments in the state at an amount of $5,000 or 1% of gross revenue, whichever is greater. And that is also for the purpose of allowing for the stated purposes that I've provided. There is the information that we've gathered that is submitted to the committee, as well as the testimony that the committee's received, concerns the correlation that exists between the adult live entertainment industry and the sexual exploitation of children. Prosecutor here today testified that this 14-year-old that was being pimped out was identified trying to get into an adult strip club, using a fake ID. This correlation we've seen exhibits both a gateway by which those that are trying to exploit children can come into contact with those kids, or come into contact rather to the pimps that can provide these children, or those pimps will go within a radius of these adult entertainment, live entertainment locations for the purpose of furthering their criminal enterprise. Madam Chair, I have prepared a fiscal note or requested a fiscal note. It was for language as originally introduced, so there have been some minor modifications. But according to the fiscal note, which I'm happy to provide to the committee, supports that over $2 million would be raised annually for support of these minors that have been victimized. And estimates that we've seen indicate that up to $100,000 a year can be required for support of minors as they're given, as they go through the rehabilitative programming and need support of housing and such. And so at a minimum, we're talking about 20 children annually that could be supported. But additionally, on top of that, according to the fiscal note, there were 800 criminal convictions in the state of Georgia last year for the offenses outlined. And as many of these offenses carry a 12-month sentence, there would be an expectation of the fee assessed on those criminal convicts of $2,500, also supporting the fund, an additional $2 million, Madam Chair. Madam Chair, this is an issue that affects all aspects of the state. Metro Atlanta, rural areas, suburban areas. It's an issue that impacts victims, as it's been documented, from ages as young as 11, and is impacting both male and female children in the Southeast and throughout the United States. It's a critical issue that I submit needs to be addressed. This legislation passed almost unanimously in the Georgia State Senate this session, I believe 53-3 or 52-3 on the companion bill. And I appreciate the committee's time and consideration, and would just ask to yield any remaining time to Representative Welch if he elects to use it, as he's worked extensively on this bill and testified at the Senate committee.
Let me let me say that's quite a summation, and you got into the mode there. I want to come back to the fiscal note, though, because you mentioned that. So do you have copies for the committee? I'm sure everybody would like to see them, or can you email it to us?
I would be happy to email it, Madam Chair, and I apologize. I will need to go back and have them update the bill number and the LC number, because this was done for House Bill 244. And so I would just need to update that, but I don't anticipate any kind of holdup to get that to the committee.
I think that'd be helpful. The plan and the schedule, Chairman Weldon's schedule, was to continue this, knowing there'd be a lot of testimony, but continue tomorrow. It's scheduled at 1:30. So if you can email that fiscal note, I'm sure the committee would appreciate it. Before I come back to you, though, is there any further testimony from Mr. Boring? Okay. And so questions now from members of the committee for either Mr. Boring or the additional information provided by Representative Estration. Let's see, Representative Oliver.
Mr. Boring, your comments about the sexual registry,
yes, ma'am.
Is that in the bill? Where is it by number? Or are you suggesting that as an addition?
I believe it is in the bill. Part of the bill lists out the actual the offenses for which somebody needs to register. It is on page 12, starting at line 396, regarding dangerous sexual offenses.
Okay, I just wasn't sure if you were saying that was an addition or that's in the bill.
No, I'm sorry. Yes, it is. It's actually in this bill. It adds it at line 406.
And in relation to the seizure of property, this is only car and money?
I don't believe it's limited to that. I think those were examples that I have of things that are used.
I'm looking at the bill, and that's what I was trying to figure out. I know if you are charging somebody with racketeering, you could seize their home.
Correct.
Is that a generally true statement?
Yes, I believe anything used in the furtherance of the crime, yes.
But in this case, I just want to make sure am I right or wrong, that you're limiting the seizure of property to the car and the money in these particular offenses?
In this code section, yes, it looks like it is to motor vehicles and...
Motor vehicles is in 4.1 and the money is in
Yes.
4.2. Is that your intent?
After discussing with them, I think that's what they're trying to limit it to. I think generally contraband in these type of cases is kind
Broader.
of overarching, very broad.
And I did not know, forgive me, I probably should know this, but I've never prosecuted myself. Typically, is it, in forfeiture, seizure, is it generally every piece of property we can find that you have, or is it case by case or crime by crime limited to certain kind of property of seizure?
It's kind of getting into an area. I don't do a lot of, because a lot of our narcotics group specializes in forfeiture of property like that. Most of the cases I prosecute are like these, and I get them at the prosecution level, not the forfeiture level. But my understanding is I think it may be more broad in other actions, in other type of crimes.
Representative Spencer.
This question is for either of you. I noticed, bringing my attention to the civil statute of limitations language starting in section 2.2. Down at the bottom, the current law is 23, age 23 or 18 plus 5, and you raise it here in the bill at 25. The state of Texas, they've just passed a bill to lift the statute of limitations. It appears to be indefinitely. How do you feel raising the statute of limitations from 23 to 2 years is sufficient to expose these traffickers? How do you justify that?
The legislation as authored and introduced, Representative Spencer, is in an effort to provide an additional period of time within which a victim could seek civil recovery, knowing, and Representative, with your work on HB 17, you're well aware that that many times, of course, the age of 23 as a cutoff is insufficient time within which for the victim to, with all that that individual is with what's on that individual as far as being in a position where he or she could take such a step as filing civil suit. Additional time is necessary and needed, and that's the basis with which the increase is provided here. Now, what that specific number should be or needs to be, the 2 additional years is provided here in this legislation, but I'm well aware that HB 17 passed the House, and I voted in favor of it, and I'm aware that that is a debate and discussion that public policymakers are determining here.
May I ask one more?
Absolutely, sir.
And I guess this is for you, sir. What are you seeing in the field when victims, obviously they're not going to come out and out their trafficker anytime soon, and what are you seeing out in the field in terms of the average age of the trafficker who wants to come forward and has the courage to out the trafficker? What are you seeing?
Oh, wow. A lot of it is victim dependent. A lot of it is family support and what they have. Honestly, if you get some of these children and they are not as deeply embedded in it, and this is maybe their first or second foray into it, they may be a lot more forthcoming. But I mean, we see them. It's shocking how young some of these people are. Generally, in the cases that I prosecute, it seems like there's always somebody in that range of 13 or 14 years old that's there, and it's not their first trip into this.
But a follow-up on that is, what are you seeing, though, in the terms of what victims are coming actually forward at a certain age after they've been out of trafficking?
Okay. Oh, out of it.
Yeah. To actually expose the trafficker.
Usually it happens when a lot of it's inadvertent, like they're discovered as a runaway or something like that. And as far as their age for when they usually come, I don't think there's an age limit on it. It really depends on the circumstances. I can't really say. It depends on the maturity of the child. I can't give an age limit for when we see them actually coming out. But I've seen a lot of success stories when you have a child who has come out and has actually given evidence to the police, and they've been investigated, and they've been worked with by some of the facilities and some of the groups that we have here in Georgia, and they're given those tools. And when you've got somebody that's 14, 15, 16 years of age, and they have an opportunity in front of them, oftentimes you can get through to them and they can be saved. Whereas some of them, when they're in it for as long as they are, we can try all we want, and it's really tough to get them out of that life.
Last question, if you would indulge me, Madam Chair.
Absolutely.
I guess I need to phrase this in a way that would you agree that there are victims that come later in life?
Oh, absolutely. I've had, in jury selection, I hate to say it like an Oprah moment, I've had a couple of times where you ask questions in jury selection. Who here has ever been a victim or knows somebody that's been a victim of sexual assault? Mm-hmm. And people will raise their hand. And then you get through to them, and I had one I remember vividly in 2005 in Cobb County. The juror started tearing up, and I just knew right then she was probably in her early 50s. I said, "Ma'am, tell me, relative to you, who was that person?" And she said, "It was me." And I asked, "How old were you?" And she said, "I was around 7. And I asked her, "When's the first time you told somebody?" And she said, "Right now."
Thank you.
Okay.
Representative Raffensperger.
Well, you made a comment about lawyers, and I'm glad I don't want to say I'm glad I'm not one, but I'm just not one. So, so to the Senate resolution on page or line 8, I'm tracking with the wording rehabilitative and social services in the state who have been. Okay, I got that, or maybe that's when I lose it. Like, how can you predict the future? And so that's where I understand it's happened. Okay, they're bad, but it's in the future. So how can you assess penalties for something that hasn't happened yet?
Right. The language that is provided is addressing the preventative measures that law enforcement could take or that could be made as a component of this. In other words, just addressing simply the needs of the victims is only one component, but also taking preventative steps, including actions that can be taken as far as education in the community, and also having a structure with which preventative measures can be made is a component of this.
If you took out those 3 words, would it change this noticeably?
It would. The preventative component is important. Not only is this legislation being proposed to address the needs of existing victims, but it's also to ensure that steps are taken to prevent this from happening in the future.
Thanks.
Is that Representative Allison? Is that you?
Yes, ma'am. Thank you, Madam Chairman. I know the hour's late and we want to hear testimony, so I agree with Representative Oliver. I'm going to hold a lot of my questions till tomorrow, but I did want to clarify one thing. Representative Stration, you said that there was going to be an additional penalty of $2,500 on some of these sexual crimes. A couple of those crimes in my reviews are misdemeanors.
Yes, sir.
So a misdemeanor which has a cap of $1,000, we're going to put an additional fine of $2,500, which is going to have to be paid in 12 months?
Well, as you're well aware, Representative, another existing misdemeanor offense is driving under the influence.
Correct.
With a fine prescribed by law.
Right.
With a fee assessed upon conviction on that offense, that would take the entire, by the way, mandatory minimum amount to be paid greater than $1,000. So just as an example, that's already in existence for other misdemeanors.
Have you thought, if you're going to keep this in there, of possibly lowering it for the misdemeanor charges? Because again, assuming it can be combined with a second charge, a judge could extend the probationary period to longer than 12 months. The clients that I've represented, and of course, you know, in my practice, if someone were to be sentenced to $3,500 in fines, that doesn't include obviously fees, probation, supervision. You're talking about a $400 payment per month just to avoid a probation violation on an underlying misdemeanor charge. That just seems a little excessive on the misdemeanor part of it.
Okay.
Is what I'm saying.
Well, it's difficult to forecast specifically. I agree with you in this sense. It's difficult to forecast the specific nature of the charges that would be brought, if there would be consecutive misdemeanors or what the circumstances might be. On the other hand, this fee was considered based upon the impact with which these crimes have on the community. And at this point, I'm happy to speak with you outside of the hearing.
Sure, but it's not going to be a discretionary up to. It's going to be a flat fee.
No, sir.
That a judge has no discretion to waive or anything like that.
Which is consistent with, I'd submit, similar fees in criminal cases.
I've never seen one on a misdemeanor that's 2.5 times, though. I understand there are certain ones, but okay, we'll talk about it later. I don't want to take up the committee's time. Thank you, Madam Chairman.
Representative Dickerson. All right. You invited Representative Welch to say a few words, but I think with his permission, I'm going to hear from a few witnesses and see if we can get through those before we hear from him. Edward Metz. Edward Metz. Just come right on up and introduce yourself to the committee.
Thank you, Madam Chairman. Testing, testing. Is this mic on?
Yes, sir.
Hi, I'm Edward Metz, and I'm here to talk on behalf of the rule of law and the principle of the Constitution, both of our state and of the United States of America. I'm looking at line item 165 in SB 8 that specifically calls out someone specifically by a group name. And then further in the bill, starting on line 305, we have specific language that places a penalty on a group of business owners without being adjudicated of guilt. They're being deemed guilty by association for being an adult entertainment industry, subject to what's pretty much a fine of $5,000 to operate in a business. And I think any good prosecuting attorney would tell you that this is a bill of attainder. And that's my argument, that this language should be struck, because the first defendant who takes this to court is likely going to win on the basis that both the Georgia State Constitution, Article 10, and Article 4, Section 9 of the U.S. Constitution specifically forbid a bill of attainder, which is singling out a person or a group without an adjudication of guilt. And that's all I have to say. Are there questions?
Just 1 second. Is that Representative Spencer? Is that you?
Well, thank you for your question. But for the non-lawyers on this committee, could you be a little bit more rudimentary in your explanation?
I've given a handout. Actually, I gave a handout. One says, what is a bill of attainder? And the other is the Georgia Constitution. All right, a bill of attainder. According to this, a bill of attainder under the U.S. Constitution says, no bill of attainder or ex post facto law shall be passed. A definition of a bill of attainder is a legislative act that singles out an individual or a group for punishment without a trial. I am not here to argue that we don't need some more stringent regulations and application of actual enforcement of sexual trafficking. That's not what this argument is about. I'm just saying that it shouldn't, if we allow a bill of attainder to be snuck through on one legislation for one group, what is to hold you back from doing it to some other group in the future? It's just a slippery slope, in my opinion.
Is that Representative Sharper?
Thank you, Madam Chair. I was looking at the same thing far as what you're talking about. I know like in liquor license and things like that, you know, they may charge $5,000 depending on what city you're in. But I was just wondering, is there already some type of fee that the adult entertainment already pays to operate their business every year on a particular state level? And I know it's probably a local level, sure, you know, because of the regular business license. But does the state charge them a fee already to do business?
Well, Representative, I would doubt that anybody on the committee is going to profess and step up to being an expert on that, but I might be wrong.
Personally, I do not know the answer to that question. I do know they have to pay city licensing fees and taxes and all that sort of thing. As far as the liquor stores go, they're selling a controlled substance.
Right.
So, you know, that kind of goes a little bit beyond just singling out a particular industry for an extra tax just because they might be guilty,
right,
without being charged.
Okay. All right, thank you.
Representative Welch.
Mr. Metz, do you own a business?
I do not.
You do not. You're aware, though, that we do charge alcohol fees and licensing fees both at state and local levels. Is that correct?
Correct.
And those are fees or taxes that are assessed against particular industries for the sale of alcohol in that particular instance. Is that correct?
Well, the stated that our other representative mentioned did mention specifically establishments or liquor stores, package stores, or whatever. And since they're already selling a controlled substance, they are voluntarily submitting to extra taxation for the privilege of selling a controlled substance.
Okay, and so would they not be because of? Are you saying because it's a controlled substance that gives the state some right to levy a tax or fee against them?
Yes.
And so then it doesn't, what about in the case of a operational tax license or occupational tax license, which is a business license at the local level? We authorize that under state constitution for counties to levy that against business operations within their jurisdictions. Are you aware of that?
I'm certainly aware of that.
Okay, and then that is also against a group of entities, businesses, if you will. And
But it's not a specific.
I'm sorry. There are
to interrupt.
specified businesses at that level which are taxed at different rates. Are you aware of that?
Depending on their income and their.
Yes. And all of those are assessments that are levied. Are those? Would you consider those to be bills of attainders as well?
I would not, because that is not a specific singling out of a particular industry type. That's broad and expansive.
Broader than the adult entertainment industry.
Correct.
Really. So, so the profession of being an attorney, we assess ourselves. The Supreme Court assesses ourselves bar dues for licensing in the state of Georgia. Is that too narrow or too broad under your thought process with respect to bills of attainder?
As far as being a member of the bar and having to pay a fee, that's like a professional licensing fee. I pay professional licensing fees, and I don't mind doing that because that's the price for me to do business. It's not a specific industry fee because of the kind of industry I'm in. Boy, that's circular, isn't it?
Yeah, that's good enough, Madam Chair.
Representative Oliver.
I know that there's a great deal of litigation over adult entertainment, and in my district, the Brookhaven is the quote-unquote leader for assessing fees against adult entertainment. And what Representative Welch is helping me do is allow me an opportunity, perhaps not with you as a witness, but sometime during this discussion, to explain whether Georgia law has addressed this specific issue that you're raising in a very general way. Are you engaged in any way with the litigation ongoing in Georgia with adult entertainment?
I am not affiliated with anyone in the adult industry.
You're here as a private citizen.
I'm here just as a private citizen, yes.
Thank you.
Any further questions from anyone on the committee for Mr. Metz? Thank you, sir. Appreciate it.
Thank you, Madam Chairman. Thank you, committee.
Jessica Salaji.
Thank you, Madam Chair. I'm actually here to also speak against Senate Bill 8. I agree that there are some issues that need to be addressed, and this bill has some great points, but I have great concern with a lot of the points. The House companion of this bill, Senate Bill 244, actually ultimately had some reforms that I think were worthwhile, which I'll get to in a few minutes, but I want to start as well with the adult entertainment establishments. My concern is not necessarily as focused on the bill of attainder, but on the fact that correlation doesn't mean we just tack on a fee. And this is an enormous arbitrary fee for a specific type of business. And while we did hear testimony that one case was related to a strip club, statistics from 2014 indicate that 70% of human trafficking victims are trafficked online. And that is an overwhelming percentage, and even if the rest of the 30% were strictly related to strip clubs, that certainly wouldn't be enough for me to only assess this fee on adult entertainment industries. Further, we know that hotels and motels, massage parlors, and even some restaurants are responsible for these types of things. So I would never advocate for further taxing Georgia businesses, but if you're going to do that, you need to address all type of establishments that have this type of activity going on within them. I do have a few concerns with the civil forfeiture. If you look on lines 344, declared to be contraband, I understand that this does not conflict with Chairman Atwood's reform that just passed the House. However, the language following it is extremely vague. It says on line 354, directly or indirectly, and then used or intended for use. And if it does in fact only address motor vehicles and assets, I would ask how you can determine whether or not money was intended for use of human trafficking. I think that's a very broad definition, and even if that's in line with our current civil forfeiture practices or what may end up being our civil forfeiture practices, I think that expanding that for this industry is not appropriate at this time. The other issue I have is with the commission that this bill creates. Commissions come with strings when they can apply for federal grants. Once you have a federal grant, then you have federal strings, and you're no longer, as a state, in control of what happens with your commission. The federal grant money can apply across the board with all different types of stipulations, and I know that with the House version, an amendment was proposed to actually remove lines 181 through 222 and put those responsibilities and powers into another commission that is already in existence. While I don't specifically believe that some of these responsibilities are the proper role of government, if we're going to do them, I don't see why we can't allocate this type of need to an existing commission instead of creating an entire new level of government. I don't think I have any other points, but if you have any questions, I'd be happy to answer them.
Any questions from the committee? Representative Spencer.
Well, thank you. What commission would you propose that you move it to?
I believe the recommendation with House Bill 244, and I know two of the sponsors are here and could possibly speak to it, but the recommendation, I believe, was for to remove the safe harbor and change it to a child advocate and advisory commission that's already in effect. Is that correct, Representative Evstration?
Yes, if you can.
If that is I don't want to speak incorrectly.
No. Yeah, that was the proposal that was discussed at the subcommittee. I have heard some concerns since that, and also it's important to note that council was not consulted with prior to the subcommittee making that addition.
Sure, and I know that there were some issues over whether or not this actual council has the authority to do some of the things, but I know that you could reallocate powers instead of creating an entire new commission, which is just one solution.
Representative Raffensperger.
Madam Chair, I don't want to go out of order. If I understand Representative's question, the determination as to the Office of the Child Advocate does not provide these kinds of services right now. And so if this were to be legislated, there would be costs, in my estimation, costs consistent with what would be involved in the creation of this council.
And if the chair could ask Representative Evstration, does your fiscal note address the cost of the commission?
It does. It was approximately. I actually don't want to misspeak, Madam Chair. May I send it to you? Would that be all right?
Any more questions? Any more questions for the witness? Thank you, ma'am.
Thank you.
And I'm going to do the best I can with this handwriting here. Linda Nathanson Lippett. I'm sorry, Representative Sharper, did I miss you? Come on up.
Thank you, Madam Chair. But I kind of had a comment in response to the couple speakers that just came up.
Yes, sir.
Because whenever we look at this bill, if we look at line 306, all the way down, let's just say to 323. When we look at it, a lot of times I look at bills, I follow the money and see what's going on with the whole thing. So I'm just wondering, and we may have had the power to do this and just set it aside from, if we just take this little section I just mentioned and take everything else away, we're maybe in a position to where we can have a fee based on that particular business, but not add everything we have on here, because I'm an entrepreneur, and as a business owner, or if somebody's interested, in that business or a business owner, I would kind of feel bad if they basically said, you're going to have to pay this particular fee because of this particular industry. And I'm wondering, is that the way that they're feeling, or they're seeing that it's basically, I'm being picked on, and I got to pay this money because you're saying that whatever my business is associated with this. You know what I mean? I think that's where I sympathize on that system as a business owner, that you're making me pay this fee because of this particular industry or what we're seeing bad things going on. So you're tying it to me automatically. You see what I mean? So I can understand that. Is that what you're kind of feeling?
Yes, sir.
In which, when you add all that together and you say, you're blaming me and I'm going to have to pay this money. But on the other side, if you just said, okay, out of the blue, we're going to charge this just because this is going to be the fee. If you want to do this particular business, this is what you're going to have to pay. A lot of times you're able to deal with that a little better, whatever business you're in. If you're an attorney, if you're in the liquor store business, sometimes you're going to have to pay a higher price because of the business that you're in. But don't necessarily blame me that I'm going to have to pay higher fees as a liquor store owner because there's so many DUIs and violence associated with it. So that would be the same thing I think that they're feeling, that you're saying because of these results for certain things, I got to pay for that. And maybe my particular establishment has not been guilty of it. We run a good operation based on what we're supposed to do, but because of that, I'm going to have to suffer. None of this went on in my establishment, but I'm having to pay the price for it. So I just wanted to put that out there to see what you feel that, as a business owner in your industry. And no, I'm not in the industry, but I'm just saying I understand your pain on that. I really do.
All right, ma'am, go right ahead and introduce yourself to the committee.
As you deciphered my doctor's handwriting, I'm Linda Nathanson-Lippett. I'm a developmental pediatrician. I was in practice here in Georgia for the last 38 years, recently retired, which gives me the time to do some advocacy for the kids that I care so very much about. And that's why I'm here today. And I was thinking of things to say until my issue of Journal of Pediatrics came, which has, and I'd like to read to you 2 paragraphs from this article titled Child Sex Trafficking and Commercial Sexual Exploitation, Healthcare Needs of Victims. So, child sex trafficking and commercial sexual exploitation of children are major public health problems in the United States and throughout the world. Despite large numbers of American and foreign youth affected and a plethora of serious physical and mental health problems associated with this, there is limited information and there is limited work for healthcare providers to protect these children. Knowledge of risk factors, recruitment factors, and possible indications of child sex trafficking is mandatory now for the general pediatrician. And the article concludes with some good bullet points that I think we need to keep in mind. A victim of child sex trafficking faces numerous challenges to existing in a life of exploitation, including emotional bonds with the exploiter, fear of retribution, reluctance to return to a dysfunctional home, ostracism by family or community, and other difficulties. It is not unusual for victims to return to the life of trafficking and exploitation, sometimes several times before finally extracting themselves. And the problems of infections, mental health problems, a variation of post-traumatic stress disorder, which takes a great deal of time and support to help these children. And by the way, they are not all girls. There are boys involved as sex slaves as well. And, you know, I'm not a lawyer, and I was in private practice. I know a little bit about licenses and stuff, but not that much. But it's time. It's time for us to get some legislation on the books so these children who are suffering so terribly can be supported and rehabilitated and given skills so they can have a meaningful life in the community. It's time. It's time that we do this.
Representative Spencer, you have a question?
Thank you, Madam Chairman. What does a prevention program look like to you, Doctor?
Wow. You know, we talk about there being runaways, throwaways, and walkaways who wind up becoming victims. And we go back to prevention first has to start with supporting the family and the home. So many of these children have been sexually exploited since toddlerhood in terribly dysfunctional homes. So part of prevention has got to be putting teeth into defects, getting enough workers in defects so that they truly can go in and see what's going on in homes, because right now they are overwhelmed. We need schools that are going to be responsive and supportive instead of just punitive. This is, you know, these are all things that need to be done for prevention. We have organizations like the Interfaith Children's Council, Interfaith Children's Movement, that are working with churches and synagogues to get out the word, to try to help support this. All of this is a total community effort. In many ways, child sex trafficking is the tip of an iceberg of social dysfunction that needs to be addressed. But at least we can start hitting the tip of the iceberg.
And you had mentioned that there was a lot of dysfunction in these folks that are at risk for being trafficked, and you had mentioned that as young as 3 years old. In your practice with maybe dealing with these types of victims, what is your sense of where these victims are actually abused by their parents or their grandparents or their family members? Are they being sold into sex trafficking by members of their own family?
Well, some yes and no. There are some families that are so poor and so hungry that they will send their 12 or 13-year-old out to turn a couple of tricks so the family can eat that night. One of the things that our synagogue with several others do at the just before holidays is we go to the food banks and we fill what we call blessing bags with 10 days worth of food for a family of 4. So when they aren't getting lunch and breakfast in school, there's food and they aren't being driven to turn tricks so that they can eat. But Sometimes it's a grandfather, sometimes it's an uncle, sometimes it's an older brother who starts sexually abusing that child in the home, and then that child thinks that that is normal. You know, that they've grown up with their bodies being violated, and very often the mother is just too depressed, too strung out on drugs or whatever to protest or get up the energy to confront the person who's doing the violation. And so these children grow up and they're ripe for being picked by the pimps.
Representative Welch.
Good afternoon, Doctor. Thank you for coming. The questions I have for you are just a series of questions. One, what in your opinion is the benefit and the need for children that have been trafficked or are caught up in sexual exploitation? What is the need and benefit of a protective environment in which they can rehabilitate?
It's essential. These children have run away or been thrown away, very often literally thrown out of the only house that they have had, very often by a stepfather who has come into the picture. And they have no place to go. And if they're going to, and you're not going to take a child who has been through such trauma and have them see somebody once a week and go back to wherever and be able to build, work through the trauma, find the skills for self-esteem. Very often they don't have any idea of how to keep track of your clothes, what to do in the kitchen, how to, what skills might they have. If they've been trafficked, their handler has been very carefully letting them know that this is the only thing they're good for, and to help build these skills so that they can be functioning, contributing members of society. And, I have met some of these absolutely remarkable women who have managed to extricate themselves with a lot of love and help from community, and who are now dedicated to extricating more people. But it's not something that happens in 90 days of rehab.
And to that point, about how long does it take? Is there a general average of how long it takes? I know it would vary from the severity from child to child, but do we have some rules of thumb?
I would think, and I would think you're probably looking at least 6 months. For some kids who were traumatized, much longer than that. And I don't, I certainly don't think you can say 90 days in a protected environment and now you've got all the skills to be out there in the world.
And what kind of later life impacts occur with the children? What are the side effects, long-term side effects of children that have been sexually exploited and may or may not receive any rehabilitative treatment?
Number one, depression, self-mutilation, suicide, very, very common long-term side effects. As the article I quoted to you points out, sexually transmitted diseases are a big problem with this population, from HIV to gonorrhea to syphilis. They will very often start abusing drugs and alcohol as a way of dealing with the psychic pain that they have experienced and that they're still dealing with.
And how do those, if you have from your experience, how do those young adults or adults that are dealing with this past trauma, how do they pay for all that treatment?
Well, very often, if they're looking whatever treatment they're getting, they're back in the life because that's the only way they know to make money.
Would you mind leaving a copy of your article for the committee?
I'll find a place, not copy it. I'll be happy to do that, or I can email it.
If you don't mind leaving it here, I think Michelle can help us with a copy.
I'll be happy. Yeah, this is March 2015, General Pediatrics. Couldn't be more appropriate.
Thank you, Madam Chair.
Do you want it?
Thank you, ma'am, very much. I don't see any more questions. And so next on the list is Juliana McConnell. Come right on up.
I'm actually not going to provide a net-length testimony. I'm here today representing Street Grace. That's the faith-based coalition of churches and community partners and individuals who have contributed their time for over 5 years now, working to eradicate the domestic minor sex trafficking of our children. We've worked especially close to 3 other organizations over the past several years, and that's Youth Spark and Wellspring and Georgia Cares. And we do have representation from all 3 of those organizations who will give you a more detailed information today. And I'm also getting ready. I'm going. We are speaking throughout the state of Georgia and have been for several years. Street Grace has. We have developed even a speakers bureau, and all 3 of these other organizations. We have such a demand throughout the state of Georgia to travel and speak. And in fact, I'm headed tonight at 7 o'clock to speak in Carroll County to a group of men and women, close to 100 individuals, speaking on this issue and giving them an update on the legislative process and how they can be involved. So thank you so much for your consideration today and allowing us an opportunity to testify today. Thank you.
Hold on just one second.
Okay.
Representative Welch wants to chat with you.
Thank you, Ms. McConnell. Thank you, Madam Chair. Is it fair to say that the organizations you just listed are all in support of this measure?
Oh, absolutely. And Street Grace, and I apologize, Street Grace does want to go on record that we do support Senate Bill 8 and Senate Resolution 7. And as you know, we've worked with both Representative Efstration and Representative Welch, as well as Senator Unerman, for the past several months. And we now have a database. When we send out emails and legislative updates, we're estimating now through all of the other organizations that many of them you'll hear from today, that we're probably pushing close to 20,000 advocates right now in the state of Georgia, just on our email basis.
And those advocates are in support of this measure?
All of them are on support and have been sending emails and telephone calls throughout the past month or so.
Thank you, Madam Chair.
Thank you.
Hold on just one moment, ma'am. We got one more. Representative Bell.
Great. Thank you, Madam Chair. Thank you so much for the work that you do. I know this has been an ongoing process for a couple of years, and I know that it has come through the Senate. Is there anything you would like to see in this bill that is not currently in the bill?
Well, there are sections, were a couple of areas that were taken out, but I'd rather wait and let those be addressed by some of our other advocates that will be testifying today.
Great, thank you.
But we do support everything that's
Absolutely.
in the bill right now, and I will say we participated week before last on a bus tour that our Public Service Commissioner Tim Eccles arranged. He called it the Unholy Tour. We had a number of legislators from the Senate and the House that went on that tour week before last, and I actually had a couple of those legislators after the tour was over came up to me and said, you know, I had a couple of issues with the legislation, and they said, after going on this tour tonight, I absolutely support the legislation in its total.
If I may, please, Madam Chair.
Absolutely.
That was my question. I have District 58, which is Metropolitan Parkway.
Oh,
And so, unfortunately, I don't have to take a bus tour. I can just walk down the street to see what's happening. So that's where my question is coming from, is having lived in that particular vicinity and see that this is an all-day, everyday process that's taking place. So I will wait for the other folks to testify. But just to let you know, my district is one of those big districts where this has been going on for so many years.
Oh, absolutely. And I have been working in this for over 5 years.
Right.
But after taking that tour the other night, I absolutely I wish every legislator would have an opportunity to go on that tour and see what is, and we were just touring right around the Atlanta area. Right. But it was just amazing and an eye-opener for many of our legislators that were there.
Thank you for your work.
Thank you.
Thank you, ma'am. Kirsten Widener.
Thank you, Madam Chair. My name is Kirsten Widener. I'm an attorney who has been working on the issue of sexual exploitation of children since the mid-2000s, first in my previous position as a representative for the Barton Center, and now as a policy advisor to the Georgia Women's Policy Institute at the YWCA. I am here to speak in favor of this legislation. The main thrust of my ability to be helpful to the committee, I think, may be to answer some of the questions raised about the adult entertainment provisions. As an advisor to the advocates for this bill, I have done some research on the constitutional provisions in particular and can speak to some of the questions that have been raised, both in terms of the correlation, but also in terms of what the Constitution requires and permits, in terms of what this body can do in responding to this issue. So if it's all right, that's where I'll start, and then I'm happy to also respond to any other questions. The Supreme Court recognizes protection for adult entertainment, but has repeatedly said that adult entertainment is at the outer ambit of what the Constitution permits. And so those protections are limited. And in particular, the case law permits the governing bodies, whether that be local, state, or federal, to govern reasonable secondary effects of the adult entertainment industry. Now, that finding of secondary effects does not require guilt. It does not require that we assume that the industry is doing this on purpose. It is saying that when you have this industry in place, there are effects that that industry has that may be totally unintentional as far as the business owners go, but that still impose costs on society that it's reasonable to regulate. Now, I will say that the Supreme Court of the U.S. nor Georgia has addressed this specific question of an assessment on those industries. However, 2 state Supreme Courts, Utah and Texas, have upheld similar fees that have been used to fund an actually slightly more tenuously related issue, which is sexual assault more generally. So here, where we have more evidence connecting specifically the sexual exploitation of children to adult entertainment, we have a much better nexus between the problem, the secondary effect that the legislation seeks to address, and the issue that we have. And in speaking about sort of what that nexus looks like, we have research that was done by the A Future Not a Past campaign that showed that 14% of recovered children who were interviewed had actually been exploited out of adult entertainment clubs. Now again, probably without the knowledge of those clubs in most cases, but had been exploited through those clubs. Additionally, the 2005 study that was done by the Atlanta Mayor's Office, Hidden in Plain View, found that arrests for prostitution were concentrated geographically, and particularly prostitution of children, were concentrated geographically right around the strip clubs. So you have evidence that this is a legitimate secondary effect of the industry, and this body, as a result, has the right to regulate those secondary effects under the Constitution. So again, while Georgia Supreme Court, to your question, Representative Oliver, has not directly addressed it because it hasn't been raised to them, and the U.S. Supreme Court has not directly addressed it, prostitution has repeatedly been a secondary effect that the U.S. Supreme Court has said the states can regulate. So I feel confident that this is a constitutional provision under the case law that exists today.
Representative Spencer.
Can you direct us anywhere in our state constitution that allows us to regulate such outer ambits as you described?
Well, the outer ambit language comes from a series of First Amendment cases. So this would come under the freedom of expression provisions of our Constitution. I cannot direct you to that exact provision, but I am happy to follow up with the committee to find it. I can direct you to specifically some of the Supreme Court case law, if that would be helpful.
I think it would also be helpful for this committee to point us out to our state constitution where that would apply, as well as the case law.
I'd be happy to follow up with the committee and provide that maybe for the hearing tomorrow.
Representative Welch.
Thank you, Madam Chair. Ms. Widener, is this this is hidden in plain view, a commercial sexual exploitation of girls in Atlanta study done by Atlanta Women's Agenda, September 2005. Is this the study you're referring to?
Yes, sir.
Okay. I'm going to leave this with the committee so that it can be here. And then also, could you provide us a copy of the other study you were referencing that has the 14% of exposure of girls in the adult entertainment establishment?
I believe that the representative that is here from Youth Spark has that detail and can provide that information.
Okay, thank you. And then, I'd like to see the cases that you're referring to. So when you have if you want to provide that to the committee in a document for us to review, that'd be great.
I'll certainly provide the document. The two most relevant cases, just so that the committee knows, are City of Erie versus Paps AM and Barnes versus Glenn Theater. Those are both within the last 20 years. And the Barnes case in particular has some language that I think is directly on point, where they say, Justice Souter said, on its face, the government interest in combating prostitution and other criminal activity is not at all inherently related to expression. This is not a First Amendment question. This is a question of the state's ability to regulate the secondary effects of business.
And if I may, Madam Chair, one more question. Have you recently read the Brookhaven case that the Georgia Supreme Court passed or decided this past year?
I am not directly familiar with that case. I believe it's a zoning case, though.
If you would just take a look at the it's Trop Inc. Doing business as Pink Pony versus the City of Brookhaven. It was decided by the justices in October 2014. And it also goes through a analysis of sexually orientated business regulation by the City of Brookhaven. It is connected with alcohol consumption and use, but it also applies what's called the Paramount Pictures test.
Yep.
And goes through and outlines the secondary effects, the pernicious secondary effects that may result from a business or an activity, and uses some of the language that you were referring to earlier. So it does seem that our Georgia Supreme Court is rendering decisions that are consistent with some of those Supreme Court decisions from our federal level.
And I'll be happy to include that in the documentation that I provide to the committee.
Thank you.
Representative Oliver.
Ms. Widener, I don't know if it is part of your plan for your testimony or perhaps one of the other advocates, but I'm assuming that somebody's going to raise the issue of ability to consent to sex and the issue of what is, in fact, a legal safe harbor. And if that is assigned to somebody else, I just want to make sure the committee hears from the advocates on that issue.
Yes, thank you for raising the issue. I had sort of skipped to the adult entertainment question because that had been a subject of previous testimony. But in general, the federal government has identified what they call the 3 Ps approach to combating human trafficking. That is prosecution of the offenders, protection of victims, and prevention of future trafficking. Georgia, and I've had the privilege to work with this body over many years on really strengthening the ability to prosecute the offenders, and the state has done an excellent job of legislating strong criminal statutes that are protective of our children in that way. What we have done less of a good job at so far is protecting our victims, and that is the reason for our support for this bill generally, because of the service protection it provides, but there are additional provisions that were in earlier drafts of the bill that we are strongly supportive of should this committee be willing to consider them. And the most important of those is what is known as legal safe harbor, which is to prevent a child from being prosecuted for the crime of prostitution when they're not legally able to consent to the act of having sex. So the idea that you could be prosecuted in juvenile court, for example, under the age of consent for prostitution is something that still does happen in different Georgia counties and something that we believe should not happen. There is suggested language that's been floated, that's been, I believe, looked at by the Prosecuting Attorney's Council that is available to the committee if that's something that the committee would like to pursue. With or without that language, we support the bill, but we would strongly favor adopting that additional protection.
Madam Chair, at some point, probably not now, I'd like to have a discussion that fleshes out that issue a little bit more.
I'll make a note of it.
Thank you.
Representative Raffensperger.
You can't consent to sex until you're 16, but how do we then prosecute a child for engaging in sex if he is not legally authorized by Georgia law to have sex? And that's a discussion that I want this committee to have at an appropriate time.
Representative, can you pull your mic a little closer to you? These folks down here may not be working.
Sorry.
You had it for a moment.
Are you sure? No, it's there. Okay. So if we're going to put a fee on, like we tax beer and liquor, and we're going to do that to strip clubs, I guess they're called adult entertainment establishments, then why don't we why can't we tax or throw fees on to porn shops and people that sell that kind of pornographic literature and material? Is that allowed in the state constitution?
My understanding is so long as the committee makes findings that there is a connection between the operation with that kind of business and the issue that you're trying to address, that you're absolutely able to do that constitutionally. It's a question of, is there that nexus? Does the committee have a reasonable belief that that nexus exists? I will say that the Supreme Court case law is really clear that you don't need to do original research. You need to have a reasonable belief that this is true based on what the study and the research that you've done.
Representative Atwood, is that you? Oh, Representative Sharper.
I'll be brief, but thank you for the information. So really, we would be, if we do this, we would be regulating this thing with fees per se. I mean, even though they have the money coming in for the safe harbor, but we must, and I say we must, not just look at this thing as trying to regulate them with some type of fee, because even though they make the money, they pay the $5,000 or whatever happening, they're still going to do business as usual. Things are going to increase. Things are going to happen. So I think we need to make sure we keep our eyes on what we can do on the enforcement level of what we're doing. That's the biggest problem. If we're not enforcing this stuff, if we're not doing enough preventive maintenance on keeping these things from happening, $5,000 a year from each adult establishment is not going to solve the problem. So this is bigger than just taxing somebody and having some money put somewhere.
I completely agree with you, sir. And to be clear, there are other provisions of this bill. For example, the requirement of a state plan that would require some kind of coordination so that our efforts at law enforcement and our efforts at victim services and our efforts at prevention are coordinated together, and the state is moving forward with that comprehensive view that you're talking about.
Okay, thank you.
Chair has just a few questions for you, if I might. Sure. In researching the bill and taking a look at this, did you take a look at the definition of fee versus tax in the Georgia Code sufficiently to have an opinion as to whether this is a tax or a fee?
My research indicated that that is an issue for the General Assembly to decide. The courts will consider this to be duly passed if the Georgia General Assembly makes the conclusion that this is something that can originate in the Senate, if that's what your question relates to. So it's a matter for this body to decide how that fits, and the courts will not disturb that decision.
We actually raised a question I hadn't thought of, which is if it's a taxing measure, it might not be able to start in the Senate. It's if it's a revenue generation measure. So thanks for that, because we'll need legislative counsel to weigh in on that. But really my question goes to whether or not the definition in the case law in terms of the function that this assessment, as it's called, serves is a fee or a tax.
It's unclear. It's unclear. The courts will defer, in my reading of the case law, the courts will defer to the body in its conclusions about that and will not disturb that conclusion.
Now, Representative Efstration indicated he was going to present evidence to support these findings that are requested that we make in section 1-2 here, particularly in lines 40 through 50 in the bill. Do you have any evidence to present in support of any of those findings in lines 40 through 50?
So again, I would refer to the hidden in plain view study that Chairman or Representative Welch has offered to provide to the committee. Additionally, the information that I believe Youth Spark is able to provide relating to the specific trafficking of children out of adult entertainment industries, I believe, goes specifically to this finding. Additionally, the pediatrics article that was cited earlier talks about the need for the services and the types of services that are needed, and I think that speaks to the critical need that these lines speak to as well.
And do you have that study electronically that was done? That I think it's called, you said hidden in plain view?
Hidden in plain view. I have a PDF version of it that I'm happy to provide to the committee.
I think that'd be helpful for everyone. And so is that the extent of the evidence on the legislative findings in, as far as you're aware, lines 40 through 50?
Madam Chair, that is the extent of the specific to Georgia findings that I'm aware of. However, again, the Supreme Court has said you don't have to make state-specific findings, that you can use the findings that have been relied on by the Supreme Court previously, as well as studies done in other locations. And there are evidence throughout the case law that I'm also going to provide the list of to the committee that speaks to those secondary effects, and that is, I think, also relevant evidence as regards these provisions.
Well, we've answered some questions, and new questions have sprung up during all that. Is that Representative Allison or Representative Chairman Atwood? Is that you?
Get it offline. She answered it. Mm-hmm.
Representative Welch, I think you were next.
Well, in addition, I just wanted to add that we've already had testimony that Representative Efstration brought to us from a DA that has prosecuted various cases, and he's given us testimony as to his experience with children that have been prostituted or and the association with the strip club industry. I'm sure he can elaborate on that further, Madam Chair.
And I believe, if I may just add, I believe Heather Stockdale, who's here from Georgia Cares, is also signed up to give testimony. Her organization provides the case management for children who are recovering from commercial sexual exploitation, and she can probably speak to that connection as well.
Representative Raffensperger, I think you're next.
I guess I keep on coming back to the money, Madam Chair. I guess this appears to be very noteworthy and something that we should look at doing. My question is, how much money do we need?
The care of an individual child who has experienced this kind of complex trauma is not just a snapshot in time, not just that perhaps 90 days in a supportive environment, but is lifelong. And that is extremely expensive care. Ms. Stockdale can speak to specifically how many children we're talking about being identified on an annual basis. But I think if we're talking about $2 million being generated by this fund based on by the fiscal note, if I'm remembering our Representative Estration's testimony correctly, we could certainly easily spend that and more.
Representative Bell?
Thank you, Madam Chair. Thank you, Kirsten. It's good to see you. So, not to muddy the waters, but we're looking at adult entertainment industries. And again, going back to my district. So we have the strip clubs, but we also have the motels. And we have the extended stay as well as the run-in and run-out type situation. So has there been any type of conversation around including them in this fee process? Has that been worked out, and or why are we leaving them out?
I'm not aware of any conversation that has occurred about that. I would defer to the bill sponsors to speak to that question. Okay. I will say that it is slightly more difficult because we have extended stay motels that deal with, for example, business travelers that may operate in a slightly different environment. I think it might be more difficult to come up with a definition that would hit the correct businesses, whereas the correlation with adult entertainment seems to be more universal to that industry and is perhaps a little easier to define.
Thank you.
Representative Spencer. All right. I think that's it. Thank you very much.
Thank you.
Next is Mary Boyert. Boyer. Come on up.
Thank you, Representative Quick and members of the committee. Thank you so much for taking the time to learn and listen about this terrible, terrible tragedy that occurs in our state and everywhere. As you said, my name is Mary Boyert, and I am the Respect Life Director of the Catholic Archdiocese of Atlanta. And for the past several years, I have personally been a member of a Street Grace organization that recently spoke. I've also been a member of, I am currently a member of the Georgia Statewide Human Trafficking Task Force, which is operated by the Criminal Justice Coordinating Council. Previously was operated by the Governor's Office for Children and Families. I'm also a member of the Georgia's Not Buying It program, which is coordinated through the GBI and the Georgia Attorney General's Office. So I am personally have taken a strong interest in this topic and have been given permission, so to speak, to add this to the issues that our Respect Life ministry covers, because it is certainly definitely against life in all sorts of ways. And as a Catholic Church, we certainly are totally opposed to any form of human trafficking, whether it's against children or adults, whether it's sex trafficking or any other type of labor trafficking. Locally, our Catholic Charities offices in the Atlanta area work with victims of human trafficking, mainly from other countries. Across the country, the Catholic Church is involved in all sorts of efforts to work against this. So we definitely support this legislation and would have supported the original version that came from the Senate as well. So I really don't have a lot of statistics other than to say that we really support this, but one of the representatives talked about the prevention and the cost needed for prevention. And I'd just like to share something that personally struck me when I was taking one of the speakers' trainings that, through Street Grace. The young lady giving the talk said to try and imagine a beautiful piece of china that you might have, and you've kept it, maybe came down from your family, from your grandparents, and if you drop that piece of china and you break it, you can put it back together with glue, but it'll never look the same as it was before it broke. And so this is why prevention and any kind of money that we can put towards prevention of this tragedy is important. Obviously, we need to do everything we can to help the children who are already victims, but we have to do whatever we can to prevent this from happening. So be happy to answer any questions, but we just basically support the bill.
Thank you, ma'am. Representative Bell.
Thanks again, Madam Chair. To your point and to Raffensperger. Hey, Brad. Welcome to the House. He's new. I haven't gotten it together yet. I think the correlation here is how much does it cost for us to house youth if we arrest them? And it's punitive, which I think is somewhere at $100,000 a year to do that. And so I think in putting the money aspect into perspective, if we're giving them 5 and 6 year sentences or whatever the going rate is now for that type of business, I think anything that we can put towards it to do the preventive, we get it on the front end rather than having to do it on the back end.
Representative Spencer.
Thank you. I want to draw your attention to the civil statute of limitations on lines 122. And you said you were affiliated with the Catholic Church. What would be, I guess, the position of the Catholic Church to provide a meaningful extension of the statute of limitations to try to uncover and expose these traffickers? What would be their position?
Well, that is not personally something that I'm an expert involved with. I somewhat limited to the Respect Life issue. So with regard to those questions, we would defer to the author of the bill and the committee to look into that. I'm really not an expert in that area.
Thank you.
Chairman Atwood.
I want to thank you for supporting and testifying. I'm older probably than most of these folks here. But I can remember long ago, I was working the Organized Crime Squad with the Atlanta Police Department before I became a federal agent. And I can remember, and it wasn't just a poor person, I can remember my partner and I arresting a woman that tried to prostitute her own daughter to pay for drugs. And she was not of humble means. Her husband was out of town, he was a salesman. And I remember that going back, and that was in the 70s that we did it. And then later I worked as a federal agent with Customs, and we did a lot of work in this area. So I absolutely support you. I'm for funding. The only problem I'm having, there's a couple of minor areas that I need to talk to the author of the bill about. The problem I'm having is the singling out of this industry. I don't like this industry at all. I would be happy closing them. I would be very happy putting money in the budget to pay for this for you. I was sitting there going through the industries the areas where I know this happens. Truck stops, motels, bars, that sort of thing, where I used to make cases long ago when I was younger. And that's the problem I'm having to wrap my arms around it, because I'm also a lawyer and I need to be constitutional in what I do, and it's something very dear to me. So I hope to sit down with the author and talk a little bit more and with Representative Estration to try to help you all with this. Thank you. And
Those
thank you
are
for
tough decisions. And
yeah, it is, but we'll work through it. And thank you very much.
Thank you, ma'am. There seem to be no more questions, so Heather Stockdale is next. And just for everyone's information, we're going till 6, as the notice said, and then we'll reconvene tomorrow at 1:30. So with that in mind, we'll try to get through as many folks as we can.
So I'll try to be as quick as possible. Would you rather me kind of go through what I have prepared or answer any of the questions that have kind of already been brought up today about number of victims and costs? What would be most helpful to you?
You can do it any way you wish to do it.
The numbers and the cost. Okay. So a few questions that were asked today is, what is the problem that we're looking at? How many victims? So just to give you a quick snapshot, last year at Georgia Cares, we served 387 child victims of sex trafficking in our state. So just to compare that, other southern states and sister states that we have, Florida did a study, and last year they said that they had 96 to 200. Don't know why the range, but that range of child victims. Mississippi just released a study, and they had 90 victims. And then Louisiana did a study and found about 100 victims. So we are already 3 to 4 times above, and I think that that's because of the great work that we've done with education and awareness across our state. We at Georgia Cares have a statewide hotline, so we receive all of the referrals for these child victims, but that kind of gives you an idea and serves to compare to other states surrounding us. To speak a little bit about the costs, I know there have been a lot of questions about that. Rehabilitative care, restoration, treatment for these children is very costly. To give you an idea of what we would pay for one child a month to put her in a safe home, I say her, we do have boys and girls, but unfortunately in the state of Georgia we have no specific DMST, which is domestic minor sex trafficking, safe homes for boys. So if we're going to pay for a girl for 1 month to receive rehabilitative care, it's $5,600 per month. So for a year we're looking at $67,000 that we would spend. Any other questions kind of about costs, and does that answer a lot of the questions that we've heard today? It's still cheaper than putting a child in juvenile detention, to your point, ma'am, but it is very costly for that. Any other?
But who pays now? I think that's what some of the questions have been about, is how are they being cared for now? Mm-hmm. Who pays? Is it being covered by criminal restitution in some way? What's going on with that funding right now?
Great question. So what I missed saying at the beginning of the testimony is that I'm the executive director of Georgia Cares. Our agency was actually created by the state in 2009, and we were previously attached to the Governor's Office for Children and Families. Since then, looking at a kind of public-private partnership approach, we've pulled off, and we are our own nonprofit 501c3 organization. We receive funds from the state, but they are actually federal funds that the state allocated back in 2009, not wanting to add money to the state budget, wanting to look at utilizing existing resources. For transparency's sake, if anyone's wondering, those are TANF funds that are used and allocated. And since working with the Criminal Justice Coordinating Council, they have helped us identify Victims of Crime Act dollars as well that we receive. So that is one funding source. The other funding sources are, we work very closely with Department of Family and Children's Services and Department of Juvenile Justice, who do have monies in their budgets for children that are under their care and guardianship. So if the child, for example, is in custody of the state, we work out with Department of Family and Children's Services. Can they cover their safe home care, for example, and we might cover extra therapeutic care for the child. So right now, just to be very honest, it's very piecemeal. The way that this works, it's not one specific funding stream. While victims can apply for crime victims compensation dollars, we've been working with CJCC to work that out, but keep in mind that those are reimbursed costs after the fact. So these children and their parents or families don't have the dollars to pay for those services up front. So most of the time they would go without those dollars, without the services. Does that fully answer your question?
It does. So
Okay.
So your agency or some agency
Mm-hmm.
is supervising the care of these child victims.
Yes, ma'am.
Okay. And so is there a budget or something that's been circulated previously as to where there's a shortfall in terms of why we're seeking to impose this, what I'll call a tax?
Yep. So I'll kind of answer, just to be honest about the budget that we have now. Back in 2009, TANF funds were isolated, as I mentioned. So we received $718,000 in TANF funds. Keep in mind that those go towards administration and kind of infrastructure, but we use over 60% of our budget directly to pay for victim services. So that's what we currently get. But as you can tell from the numbers that I've provided, that only provides care for a small number of the 387 kids that we have now.
And the shortfall comes then from where right now? Or
Meaning, what do we do when we don't have the dollars to pay for those
yes,
services?
ma'am. Who's caring for the children?
So we work with DFACS and DJJ, honestly, to try to work out a deal where maybe one agency can pay half, the other agency can pay half. But we have a wait list for services for victims. So when we don't have the dollars to pay for children to get into a safe home, for example, we only have 31 beds in the state that stay mostly full. And then when we don't have the funds to pay, we put them on a wait list until we do have the funds to pay. So for an example, right now we have 5 youth that need safe home care. that we can't pay for, but that doesn't include the children who are in the community whose services can't be covered.
Chairman Atwood.
I think you answered my question. $5,600, that's residency, right?
Yes,
24
sir.
hours a day?
Yes, sir.
Compared to $91,000 a year to incarcerate a child, that's not that bad.
Mhm.
I would make a suggestion that you talk to the chairman of the Appropriations Subcommittee for Public Safety.
Mhm.
That's me. So I'll give you a good ear.
Okay, thank you.
Representative Estration, did you have something to add?
Yes, thank you. Just to clarify this, there is no, Ms. Stockdale, there is no appropriation made by the General Assembly,
No, sir.
correct?
That's
correct. And so any funding that's currently being received by the state is not being appropriated to one overarching agency that's overseeing that, correct?
Agreed. Yes.
All right. And also, because of your current status as well, it would be unconstitutional for us to delegate legislative authority to you to make certain determinations because of your classification.
As a nonprofit. That's how I understand it.
Okay. Thank you.
I'm not a constitutional expert, I will say that, but yes.
Representative Welch.
Does the $6,500 per month, does that include medical costs, treatment costs, and those kind of services, or is it just the room and board?
So that's a great point. The rate that we pay is $187.84 a day. That is based off of the maximum RBWO rate that the state has agreed upon to pay for. So basically it pays for room, board, and watchful oversight for these children. So that's a great point. The groups and safe homes that we work with, as well as our agency, often have to raise the funds to cover all of the services that aren't covered by room and board, that being group therapy, family therapy, individual counseling, medical care, and costs.
And what are those costs? Can you give us some numbers relevant to those costs, either per child or lump sum?
Yeah, so they vary depending on the child and depending on their needs. I know that's not a great answer, but I have a sheet that I've sent to Chairman Weldon, and we did our best to average out and break down those costs per child, what it would cost. I'm happy to provide that to the committee if you think that would be helpful.
Please.
Yes, sir.
Representative Spencer.
Are these children on Medicaid when they come to you?
So sometimes they are. Most of the time, those kids fall under Department of Family and Children Services when they are under Medicaid. We have tried to work with Medicaid and the state's new system through AmeriGroup. That comes with its own challenges.
Mm-hmm.
So yes and no. If that
So would they, because the foster system, they're through AmeriGroup or WellCare.
Mhm.
So have you discussed with the state about that option?
So
that's a resource that already exists.
So yes, sir, we have spoken to the state, but it's my understanding that there is a different classification, and that for us to become a Medicaid or core provider, as they put it, that's a separate and different classification, not typically meant for a victim service 501c3 organization, as it was explained to me.
I just want to make the committee aware that, that is a resource available that is an option that we need to consider instead of, I guess, tacking on, not to abuse that word.
Representative Bell.
Thank you, Madam Chair. I had a question about Medicaid as well, and then considering any cuts that we as a state are trying to make and understand where our federal dollars are coming to. So my question was, are they eligible for Medicaid, either if they come in with it or once they're in your services, do you try to connect them with Medicaid?
Yes, we absolutely try to connect them. Absolutely. Some do come to us with Medicaid, which makes it a little bit easier because we can tell them how to get reimbursed for those things. Again, that's a little tricky with our victims, and it's an extra step for them to have to go to get those services, which is also tough because this is a very transient population. If that answers your question.
That does. And Madam Chair, I have one follow-up question. So I want to figure out, I know a couple of years ago, and this may still be the case, and based on the numbers that you've given us with 387 in Atlanta, Atlanta is a hotbed for this. Is that correct? It's almost like a destination for people coming from out of town to traffic. Correct me if I'm wrong, but there was a movie that was out maybe a couple of years ago, The Candy Store. Does that connect with this particular issue?
Yeah, the Candy Shop was
Candy
the
Shop,
name
okay.
of the video, and Street Grace, who was actually here before, partnered with them on that video. But you are correct that Atlanta is a hub. FBI did a study and published the top 14 cities with the highest incidence of commercial sexual exploitation and trafficking of children, and Atlanta was one of the top 14 cities.
Right, thank you.
Representative Oliver.
The Medicaid piece is a huge discussion that's in conflict and ongoing contentious stuff. But in relation to funding, lines 219 to 222, when we get to a discussion, I want somebody to explain to me, if you have an independent board, on line 220, it says that any fund must be approved by the governor, and I'm raising this issue for the committee because there's an ongoing legal conflict. Maybe it's only a conflict to me because I'm generating questions about the misuse of the Children's Trust Fund money. That's another designated fund that has been, in my view, and I've had a lot of discussions both with AG and about its mishandling or misappropriation or non-legal example of a designated fund that then makes funds out for a specific purpose. So this language, 219 to 222, if this provision stays in, somebody's going to need to explain to me why an independent board suggestion of service, how it's going to go through the appropriations and how it's going to be quote-unquote approved by the governor.
And
Very big issue in designated funds.
Yes, ma'am. And I'm aware of the trust fund that you speak of, and I think previously, and I think it still is attached to the Governor's Office for Children and Families.
Oh, we're in a debate about where it is and where the money is and where it come from and where's it going.
I think that that's a great point. As I understand it, the commission, as that independent board that you're speaking of, would generate, I guess, a list of approved grants or dollars to be funded towards certain organizations, and that list would basically annually go to the governor's office for approval. So that's how I understand it, but I think that you raise a great point, and I certainly understand your concerns.
Representative Welch.
Thank you, Madam Chair. Ms. Stockdale, just a couple of questions. Did you hear the fiscal note that was reported by Representative Abstration with respect to the money that the bill, as it's presented, would raise?
Yes, sir. The $2 million.
Yes, and would that be meaningful assistance to providing the rehabilitative services and preventive services or the rehabilitative services and the housing and the watchful oversight, the medical treatment, et cetera, that Georgia Care provides, and then other organizations besides your organization provide those same sheltering services? So it's not just Georgia Cares. There are several other organizations that provide this service that you're not even touching on what their expenses or cost are in your testimony. Is that correct?
Absolutely. That's absolutely correct.
So we're just talking about what Georgia Cares speaks to. We're not talking about the other organizations like Living Waters for Girls or other organizations that are providing care with private dollars and some federal grant money. Is that correct?
Yes, sir.
So is Georgia Cares in support of this measure?
Absolutely. I think that, as Ms. Widener put it earlier, we could use the $2 million for services and plus more. I think that it would absolutely be helpful towards getting these kids the services that they need. It could possibly eliminate the wait list that we currently have for services, and make sure that more kids have access to the quality and care and services that they need for their treatment.
Thank you.
There are no more questions. Did you have anything else you wanted to say? Because the chair has just one question that I'd like to end us with before we reconvene tomorrow.
I have just one more thing, Madam
Yes,
Chair.
ma'am.
Thank you for the opportunity. I know that your question previously was about support and findings to support the connection between adult entertainment. And I think we've talked about several articles and reports. I did want to mention one additional one that I felt was kind of left out. There was a Chicago study done of 113 men who purchased sex, and 84% of those men reported at least one instance of buying sex indoors of an adult entertainment establishment. And of those locations, they kind of broke down which types of establishments. 46% reported purchasing sex from a strip club, 36% reported buying through an escort agency, and 31% through a lap dance club. I'm not sure what the definition of lap dance versus strip club is, but wanted to provide that. Maybe you know. And of the 113 Chicago men who purchased sex, over 18% reported first purchasing sex from a club and an adult entertainment establishment. And then of note, because we work with children, 49% of the men thought that there were girls 18 or younger who were working at the establishments that they mentioned. So that's one more study. I've also submitted this to Chairman Weldon, but I'd be happy to submit it to all members of the committee for your consideration.
Anything else you want to say on that?
No, ma'am.
And with all due respect, Chicago's well and good, and what people think is well and good, but we've got 387 children, actual children. And my question is, how many of our Georgia children that we're talking about have a direct nexus and connection to the adult entertainment industry?
I can research and pull the numbers and statistics that we have. That is not a specific question that we ask children, because we work on a therapeutic and treatment research-based assessment that we work with them on. Whenever it is reported to us that children were involved in an adult entertainment establishment or were recruited or groomed through such, that's something that we report to law enforcement, because we focus specifically on care and services for kids. So I think maybe between my numbers and research and law enforcement, particularly FBI and GBI who we work with, perhaps we could generate a better statistic for you on that.
Thank you. And now I've generated a question from Representative Oliver, as frequently happens.
It frequently happens. Forgive me. But we understand from the law, from Ms. Widener, and she's going to give us the case law, that you don't have to tie it directly to a victim in order for it to be constitutional.
Yes, ma'am.
If Ms. Widener's right, and my guess is she's right.
Yeah, my guess too.
The nexus is not directly, individually necessary to be proved.
Mm-hmm. I would agree, if I'm allowed to.
Representative Evstration.
Thank you, Madam Chair. Ms. Stockdale, you were present today also for Mr. Boring's testimony identifying a specific child, actually I think 2 specific cases here in Georgia. Were you not?
Yes, sir.
And you also heard the citation to 2 different studies here in the state of Georgia concerning that, or at least one study here in the state of Georgia with testimony provided. Were you present for that?
Yes, sir.
All right, thank you.
Representative Sharper.
Quickly, thank you, Madam Chair. You said that you have 31 beds.
Yes.
Here, I just want to get information. The $67,000, how long of treatment will a child usually get? Is that the full year for that one child?
Yes, sir. That would be the full year for the one child. And there was a question asked earlier that I did fail to answer, so thank you for bringing that up. How long typically do kids stay in the restorative care? My comments would be that this is a lifelong struggle that these children deal with, even as adults. That trauma that they've endured is not something I think that you can quickly overcome or even completely ever overcome. But for our kids, when we're talking specifically about intensive shelter rehabilitative care, we average about 12 months that they stay in that safe home and shelter. So yes, that cost, that $67,000 would be for one child for 12 months.
Okay, and it's interesting, and not saying that you did this, but it's interesting that the 31 beds that you have with $67,000 will be exactly almost $2 million. So we can give you all of it.
Kind of works out.
Yeah.
Representative Spencer.
Where do they go after 12 months? Or are they placed in a where they go?
Yeah, that's a great question. So we work when they're nearing the end of their 12 months, just similar to other community programs. We really try to work to slowly introduce them back into the environment. understanding and knowing and being sensitive to the fact that that environment is often the environment that they were first groomed or trafficked in. So at that same time, we're working with their family or whatever guardian that they're with to help them understand some of the effects that they would have, and we're slowly reintroducing them to that environment. Now, for other kids, we work with independent living programs to move them into that. So, for example, if it's a child that's in Department of Family and Children's Services, don't have necessarily a home to go back to, most of those kids we try to transition into independent living skills, which seems to be a good option for them because they learn those independent skills towards the end of their 12 months, and then they're able to apply them. And of course, we at Georgia Cares stay with them throughout their journey, whether it's in safe home, in a group home, no matter where it is. So we stay involved until they are an adult, and we check in with them and have safety plans and all sorts of things to encourage and sustain their progress. So it depends on the child. I know that's probably not a great answer, but.
And they just keep coming, Representative Bell.
As a follow-up to that, with the work that I've done in the past with community organizing and working with a lot of these young women, if they, and this, I'm not sure what the numbers would be, so I'm not even going to throw out like a percentage, but I do know that young women are completely helped by this, where they may not ever get back to 100%, there is a great possibility that they can lead productive lives. I myself have a lot of little sisters running around the city of Atlanta, and once we can shift their paradigm and that someone does care about them without exploiting them, and they get that support service like Someone Cares, which is also in my district. So there are nonprofits out there that are available to pick up after you all do the particular work, and I think that's great to know. I myself have a 26-year-old little sister who is now married, has children. We found her when she was 13 years old. She came to the church. She had a 42-year-old boyfriend type situation. She didn't know anything about prophylactic use or anything. That was her way of being loved, and he prostituted her out. So I think if we look at how people are being helped, there are great stories just here in the city of Atlanta of young women who have been greatly affected by this. It's not to say that they don't have continuing problems, but I think we all do at some point.
Absolutely.
But, you know, just again in support of the bill.
And another thing, if I may, Madam Chair.
Absolutely.
My last comment. One thing that I would like to add to that is that we kind of talk about this akin to domestic violence or substance abuse, where there certainly is a cycle, and there sometimes is relapse. But one statistic that I'm very proud of for our agency is after completing our program and being involved in Georgia Cares, 78% of the youth who complete the program do not recidivate and do not return to the life. So I'm very proud of that statistic, and I definitely think that that speaks to your comment.
All right. Well, we will adjourn, and we will reconvene at 1:30 tomorrow in 506 CLOB.